Yep,
You're ready?
and we're live.
Good afternoon, everyone. I'm Lucas Binken with the Iowa State Association of Counties. Thank you for joining us this afternoon. Today, we're going to be talking about wind energy conversion property and specifically on the taxation and assessment of that property, and also some legislation that passed this year that you've been getting updates about in our weekly newsletters, and that has led to a lot of questions. And so we made the decision to have a webinar on the topic and kind of talk about it, I guess, generally, and then also address some of the questions that have come in about that assessment, taxation, and then what changes the new law will have. So joining us today, we have Nick Belke, tax attorney with the Department of Revenue, and Roland Simmons, property appraiser with the Department of Revenue. And so I will briefly talk about, I guess, overall, what we're going to address. As you know, there's special valuation for wind energy property in Iowa. 427B.26 in the Iowa Code allows for special valuation of this property. So we use the net acquisition cost of the property rather than market value, like what we would see for residential, commercial, other classes of property. And this puts in place a special valuation based on the net acquisition costs. And we start at 0% and increase 5% per year, going up to 30% would be the taxable value of that net acquisition cost. So most counties that have wind energy coming in have this ordinance in place for the special valuation. And I think some of the questions that have come about are from counties that have or are considering doing away with that. And so then what happens? And Roland, I think, is going to touch on how the utility replacement tax kind of comes into play. So the legislation that passed this year was actually just signed on Monday by the governor, Senate File 2366, largely clarifying, but there was discussion, I think, among assessors and probably the department on what exactly happens when we have repowering. And repowering is the term used for when blades, motors, other components are replaced. And so this legislation addresses that and basically says we're going to keep the same schedule, the same net acquisition costs. We're not adding any value, even if the property kind of changes. And we're not going to mess with the schedule. So if you started that stair step from 0% up to 30%, say you're up to 15%, that doesn't change. You don't go back to zero. This legislation actually came as a recommendation from the Utility Replacement Tax Task Force. And we've talked about that enough that I can get that out without stumbling, kind of a tongue twister there. But the task force was actually considering some other ideas, and I believe the Department of Revenue said this task force really needs to look at this issue to make sure assessors statewide are treating these properties the same, especially in the cases of repowering. And so we got to an agreement that basically said we're going to keep the status quo, keep the original net acquisition costs, and keep the original schedule. The recommendations from the task force and ultimately in the legislation also address what happens if that ordinance and special valuation is repealed, and then a process for getting over to the replacement tax. And finally, it addressed what property is all included and included collector substations that were not previously defined. So that's kind of an overview, very high level overview of how the property is treated. The clarifying language included in the legislation, again, that's Senate File 2366. And I know everyone's been probably reading about that in our newsletters. And as I said before, we were getting some questions, maybe some misunderstanding going on or need for clarification. that's the reason that we're here today. So with that, I will turn it over to Roland, who's going to be discussing sort of the impact this might have on the property, how the utility replacement tax works if the special valuation isn't in place, and I guess any other wisdom you'd like to share with us, Roland. And thank you for being here.
Well, I don't know that I'm going to get into all of those details, but I'm going to get into more of how the replacement tax works, more so than the effects of it on wind energy property. So just a little bit of history and the background on this tax. This tax started in 1999. Part of the reason was due to the climate in Iowa, with a lot of changes in the climate and the uncertainty of the overall assessments annually. Task force was put together and with the help of others to figure out a way to better serve the counties, the companies in the state of Iowa. So this tax came about. We used to do an old traditional property tax of stock and debt income and cost to come up with an assessed value for companies. And now we've gone to this replacement tax. So the replacement tax itself is a two-pronged tax. It has two components to it. One, you would have the overall replacement tax, which would be could be a generation tax, a delivery tax, and a transmission tax. One company could have just one of those taxes, or you could have all three taxes. A company that has all three taxes, that would be considered their total replacement tax. A company that should have one, that would be considered a total replacement tax. The second component of this tax is the statewide property tax. The statewide property tax was put in place to administer the replacement tax. So this tax is a 3 cents per $1,000 of assessed value for a company. And that is arrived at. We would ask the company for their acquisition cost of any of their utility property, any property that we consider operating property of a utility company. We would want to know their acquisition costs. We would use that information to come up with an assessed value for each company. Monies generated from the statewide property tax, again, it's a 3 cents per $1,000 tax. That money would be paid to the state of Iowa and deposited in the general fund. And as far as, a timeline on how things work with the replacement tax, what we would do is, so let's take an example of a new company coming into the replacement tax system. We would need to know from each individual companies their total costs of their assets by taxing district. So as part of our timeline, every October, we ask the company to report what we have is what we call an estimated replacement tax. In the case of a new company coming on board, we would ask them to report their total generation, their total deliveries, or their total transmission line property. We will want to know those by taxing districts so that any revenues or any money generated from that would be allocated to those appropriate taxing districts. This is done, like I said, is done annually in the fall, on or before October 1st. Once we have that information from the companies, we would generate their total replacement tax, allocate it amongst the local taxing districts, provide that information to the county auditors. They were able to come to our website and pick up what we would call a taxable value. They would use this taxable value to back into what they would using their taxing district rate that would let them know what they could anticipate to have for a replacement tax payment in that particular taxing district. And this has to be completed on or before October 31st. In January, we would send out to companies, we would notify them of their statewide property tax payment that is due by March 31st. We would also notify each company that they were able to come to our website and pick up what we call replacement tax form A and replacement tax form C. Replacement tax form A is where each utility company would put their actual amounts on, their actual deliveries, their actual transmission lines, and their actual generations. The part that I was talking about that we're providing to the auditors in October is an estimate. The Form A is the actual amounts. So they would come to our website, grab a form, fill it out, submit it back to the Department of Revenue. This all has to be done and completed by March 31st. Once we've compiled and calculated all replacement tax amounts, we would then send that information over to the Department of Management, who would be in charge of allocating those replacement tax dollars amongst those local taxing districts back to the Treasurer's office. So the estimated replacement tax process has worked, I think, quite smoothly. I've been at this the tax has been 23 years, I think, right now. And just looking at the current year, between the estimate and the actuals, there's a 1.3% difference. So provided the right information to the department, we can provide the correct information to the counties, and they can be assured that that tax they could expect at the local level would be pretty similar. It shouldn't be off unless we had some reporting error. It would be pretty similar. So I would say that you could be comfortable with the estimates that the Department of Revenue sends out. We've not had many issues with the estimates. So once we pass on that information to Department of Management and they allocate it to the local, allocate it to the Treasurer's office, then those payments are treated just like your traditional property tax. The first installments would be in September. The second installment would be in March. But again, this is an excise tax, but it's treated like a property tax. As far as the wind energy conversion property, it's I don't know. We don't know enough about that information as far as their generation goes, or the department has never assessed any wind energy properties to be able to contemplate any type of tax that would be generated from those. So the information I can provide you is how the tax work and how it would work if those energy companies were to come aboard. We would need a host of information from them to provide any type of estimates of any type of situations. So this is only for companies that are under the replacement tax, those estimates that we provide. So with that being said, that's my take on what, how this tax works. And if there's some questions later, I'd be more than happy to answer.
Thanks, Roland. And one thing that jumped out is I guess we'll call it the predictability. You mentioned how close those estimates are. And it reminded me of the conversation with the task force. And one of the main goals of ISAC, who is a member of the task force, was to bring about some predictability and stability. And so, getting to a point where we keep, as I discussed before, keep the schedule, keep the net acquisition costs, and continue to do business as we have been for the assessors, for county supervisors, looking at budgets and revenues coming in. That stability was very important. So whether you're talking on the special valuation side or the replacement tax side. I think that's very important for counties to kind of have that predictability as they're looking at revenues coming in, as they're trying to set budgets. That's very important. So I appreciate you mentioning that.
You bet.
And to your last point, we will be taking questions. So viewers, if you want to use the chat feature, we'll be monitoring that, and I can ask those questions as they come in. But we have been receiving some both ahead of when we decided to do this webinar, and then after we put out the information and asked for questions, we got some. And I have had the pleasure of bothering Nick almost continually with questions that have come in, very good questions on a lot of what ifs, or have we contemplated this? Has there been any guidance on that? So I think with that, I will kind of open it up to Nick to kind of address some of the themes. And then again, if you have specific questions, put those in the chat, and just know that some things could be too specific, or if we're getting to an area where guidance is needed, the Department of Revenue is maybe not always the best. I mean, they're qualified, but that's not their position to give guidance to counties. A lot of things counties will need to evaluate on their own, their financial situation, what's going on as far as development or an ordinance in place in their county. So some things are very specific to your individual county, and the department is not in that position to offer guidance. But as far as questions that have come in, I think we'll take the time now to address some of those. Nick?
Thanks, Lucas. And yeah, I'll start with two things. One, I'm a little sick right now, so if I start coughing or sniffling or anything like that, I apologize. I'll try to go on mute so you don't have to experience that. And then just I appreciate that sort of intro, Lucas, and just some additional clarifying points. I'm not your county attorney, so I can't give you legal advice. Nothing that I'm saying here today should be construed as legal advice, but I do want to help. The Department of Revenue is the tax administration agency, and so we're here to try to help to the extent that we can. And then as some of these questions have come in, I know that some counties don't want wind turbines at all. I'm aware of some of those issues, and I guess I don't have a seat on the task force. I was present for the meetings. I'm certainly not a legislator or a lobbyist. It's the Department of Revenue's role to administer the tax in a way that makes sense. And we were receiving many questions about how these properties should be taxed if they come off special valuation. After some legal research was done by a number of attorneys, it became clear that was an outstanding question that needed clarification from the legislature. I think everyone's familiar with the repowering issue that came up too, and needed some clarification as well. And then of course, the interconnect substation. So, just want to make sure that my role is understood, and I will do the best I can to answer your questions to the extent that I can. I might have to pause and think for a second. I might have to say, hey, that's a great question that I haven't thought of. Let me go back and do some research before I get back with you. So that's possible too. With that said, I'm going to start with two questions that we received ahead of time. And I'm actually going to answer them in reverse order of what I received. So the first question is, will counties be able to change between the two taxing options at any time, even after a wind farm is under construction or built? So in other words, I think it's understood that we've either got the special valuation, which you've got your 5% increment year over year until you reach 30% of the net acquisition cost of the property, which I thought Lucas did a nice job of distinguishing the net acquisition cost from the market value, which is what property is typically assessed at. You use that cost and a percentage of that cost. It's not a percentage of the actual assessed value. And then the other option, of course, which Roland discussed in much better detail than I ever could, is the replacement tax. My sort of off the cuff answer to this is that I think the plain language of the statute would allow you to switch between the options at any time, but I want to provide a couple caveats there. I mean, one, remember that once an ordinance is in place, you're kind of stuck with it for that 19-year period under the statute. So it's not like you can flip-flop that easily. You're kind of committed to it for a period of time under the statute if you pass it. And two, I think you're asking about when the properties are under construction or built. I think you may run into issues that you might want to discuss with your county attorney if you've sort of agreed to tax the property a certain way, and then you kind of flip-flop on that. Again, I think the plain language of the statute would allow you to do that, but your county attorney might want to assess some risk there in the event that you decide to sort of make a quick change. So hopefully that answers that question. And then the second question that we received is, I think, a really good question that I don't have a satisfying answer for. How do we determine the difference in revenues between the two taxation options, the special valuation versus the replacement tax? Can an example be provided for the difference in revenues using an existing wind farm, including how the wind utility replacement tax will be calculated and distributed for that farm? I think Roland answered this question sort of inadvertently better than I can. We don't assess wind farms today, so we don't have that information available to us. So we don't have an example there. I think it's a great question for a board member to ask, of course, and you will want to know the revenue difference before you make this decision. I think our recommendation is, and Roland, you can jump in if I'm stepping on toes, or you can kind of reel me back, but we think that taxpayers will hand over that information needed to make this decision. And this really isn't a legal answer. We just think in practice that the taxpayer will give you the information that you need to calculate the generation tax, which is a pretty straightforward calculation. So you think that's right, Roland, or am I misstating things?
No, I think that's correct. I think the taxpayer would be more than happy to provide that information. And as the statute reads, the generation tax is 0.06 of a cent per kilowatt hour. Knowing that information, knowing that you would need to know, the locations of the property, the taxing districts, the company themselves will provide the overall generation for those wind farms in certain taxing districts, and use the 600% per kilowatt hour. You can figure out, compare that to what you are receiving locally now, and compare it to what you could potentially receive from the generation tax by getting that information from the utility company.
Thanks, Roland. I see there are a few questions in the chat. Lucas, remind me how we decided we were going to administer that.
So I think I'll touch on the one dealing with what happens if an ordinance is repealed. So the first thing I'll say is there was no discussion about moving to a market value. The discussion was largely, are we going to do special valuation or in the case of repeal, go to the replacement tax. So I think supervisors with their mind on, hey, bringing in more revenue lowers, the tax asking for other property owners. So why not look at 90%? That's larger than 30%. Never really a part of the conversation. I don't think that's a real possibility. I will clarify that it would be under industrial, not commercial, but both, of course, are at 90%. But basically, we're with these two options. It's the 427B 26 special valuation, or going over to a replacement tax. So again, the task force came together with stakeholders, both sides, and coming up with what could work for everyone. And again, I would go back to the stability piece. A fixed number like net acquisition cost, and knowing 5% increase every year, knowing that it's going to freeze at 30, the stability and predictability that brings is really very important. To be chasing market value, especially with properties like this, could be very unpredictable, and maybe not as good as some might think. Also, the secondary market is, from my understanding, pretty limited. So having comparable sales to try and figure out what the market value might be could be very difficult. And I think there would be, for lack of better phrasing, a lot of chasing, trying to figure out, okay, what is this market value going to be? What is our projected revenue from these properties? So the stability, again, is something that's very important. Another question that came in was,
can I just jump in on that just a little
please.
bit? I'm sorry to interrupt you, but yeah, I agree with everything you mentioned, Lucas, and I just have two things to touch on too. I think it's sort of I've seen this stated multiple times, and I think it's sort of a misconception that this bill removes the authority for local governments to assess these properties at market value. That's the legal question that multiple people were tasked with trying to address, and that was not clear in the code. You've got one code section saying one thing and another code section saying another, which is why it was brought to the legislature to say, hey, what do you think here? And then the other thing too I want to mention about trying to assess these things at market value is, I think you'd see appeals going through the Board of Review, through PAB, District Court, probably up to the Court of Appeals and the Supreme Court pretty often, trying to guess at the market value of these things. Because like you mentioned, Lucas, they're just not really purchased and sold very often. So that's a challenge. And we receive concerns from assessors, how do I value these things if this is how the legislature comes down? So just wanted to mention those two things really quick. Thanks for letting me interrupt you.
I appreciate it. And some of the other questions, I think we kind of touched around the edges on this, but related to when the utility replacement tax is in place, getting information from the utility companies. So first, on providing those reports, I guess speaking to maybe the accuracy, we kind of touched on that a little bit. Is there an audit process for that? And then one of the follow-ups kind of similarly was, are there concerns on proprietary information or things that shouldn't be public from the companies as we're trying to figure out their generation and how to calculate the replacement tax?
Roland, could you talk about, sounds like you're about to jump in, but could you talk about the reporting requirement and how we ensure that information that's being provided to us is good?
Yeah. if we need to audit a company, we have our duty and responsibilities where we can, under statute, we could audit them. But, based on information that I've received over the years, that hasn't been a problem when you compare certain calculations from previous years to other companies. They're generally in line with where they should be. As far as reporting wise, there are some things that, I'm not allowed to tell anyone what a utility companies deliver for their deliveries, their deliveries for electricity or any of that type of information. Those are statutorily things that the Department of Revenue are not allowed to give out or provide to anyone. But to ensure that, these companies are reporting accurately, we do take a look at a deep dive at some of their reporting as far as their, total deliveries, their transmission line property. We do take a look at that stuff. And so it's, I don't think you'll have a problem with the accuracy of that type of information coming from these utility companies.
And we had another question, and I might need whoever submitted this to maybe give a little more detail, but the question was, what was the figure on per kilowatt hour that Roland was stating? And I'm not familiar with.
Well, I think he was talking about the generation tax. It's 0.06% per kilowatt hour, 0.0006.
Okay, and then also on the company's reporting, there was a question about different kinds of energy being produced and why not have them report like they do now? And I'm assuming that's in reference to treating wind like other energy. Does that question make sense?
I'm not sure. Or if it's a question, are they asking why don't we have wind energy property reporting? Like replacement tax?
The situation is the companies are producing energy. So if it comes from coal, nuclear, wind, solar, it's still power. So why try to reinvent? Why not have them report like they do now?
I guess my quick and easy answer, and Roland, you can tell me if I'm off base here, but the generation tax does treat the generation of energy the same across that coal, nuclear, wind, and solar, doesn't it?
Yes, it does.
And so I guess I would view that bigger question there of, why does 427B26 exist? Why is there special valuation for wind energy? As one that I'm not really in a position to answer. I guess I'd say that's probably a question for your legislator.
And several questions kind of all in the same arena, and that's related to if there's no ordinance in place, the public input, the amount of information that the Board of Supervisors and the county have from the energy company. So Nick, I think we received these sorts of questions in the past, and you kind of did some analysis on that. Would you mind tackling that as far as what information is available, what the public knows? Are there going to be any sorts of hearings to kind of get to that place of being a good neighbor? You're having those initial conversations to let property owners know what's going on, let the Board of Supervisors know what's going on.
Yeah. The first thing I want to point out is that I think these are valid concerns, but we're getting away from tax questions. here with these questions about public review and notice and all of that. And I know that practically speaking, the way that folks got notice in the past was wind energy companies coming to the board and saying, hey, we want to build here, but we probably won't do that unless you pass an ordinance under 427B26. I can't give the legal advice here, but my recommendation is to talk to your county attorney about what kind of ordinance you can pass in your county to make sure that a company that wants to come in and build wind has to let people know about it. I think that's probably the best answer I can give. Roland, is there any notice built in with the replacement tax? I would sure think not.
No, not to my knowledge.
Okay, and another question on if they are using 427B.26, so the ordinance is in place. That, of course, applies to the entire county, meaning the Board of Supervisors can't really pick and choose if they're going to allow it for one project and then maybe a different energy company comes in and they say, not for you. So they can't do that. But the question then, I guess, digs a little bit more to say, what power does the company have to elect to be under that special valuation or go to replacement tax?
I think this is a really good question. I'm going to have to do a little bit more digging there, but the way that this has been treated in the past is as a sort of unilateral decision by the county board. I don't think the issue has come up where a taxpayer has said, I'm not going to file a notice of intent because I don't want to be taxed under the special valuation. I want the other treatment. And so I don't want to answer for sure, but I know that in the past it's been treated as a unilateral decision for the county board. However, I see the reading. I think it's a great question.
And another question, at the end of 19 years, does it continue at 30%? Would that be a time to go to replacement? So the 19 years is built in to get away from the 30%. And I'm not sure, Roland or Nick, who wants to kind of address that transition. So if you repeal, you start the clock, or it actually backdates to the point of construction, the 19 years. And then the transition is kind of built into the law then, correct?
I think you stated correctly, yeah. And again, the 19 years only ends if you decide to repeal your ordinance. So if you decide you're happy with the special valuation, you can continue it.
And then we did have a question about sample ordinances, and I would say for purposes of today, we'll just leave that question. I believe ISAC does have sample ordinances. If not, Basecamp would be a great tool to reach out to some of your counterparts in other counties that have already passed an ordinance to start to get a template if you were looking to put something in place now. Then I believe we're starting to get through most of the questions on the Q&A, but I see the chat is also busy. So we've got two different avenues that people are using here. So if there's no special ordinance, can wind and energy move in without the Board of Supervisors approval? And then would they automatically use the replacement tax? So that's kind of multi-part, and I think we've kind of touched around the edges on that, and maybe it gets to, how much power there is on each side, how much notice, what the public knows and when. But as far as automatic, if the ordinance is in place, then it goes to the special valuation. And then the law also dictates, for repeal, again, what we've talked about, starting at 19 years and then switching over to the replacement tax. So I think we maybe have covered that question, unless either of you has anything else to add on there.
Oh, I think that's right. I mean, if
Yeah,
I don't know
agree.
the answer to the first part of the question as to, what all needs to be done prior to an energy company coming in and building. But if they come in and build and there's not been an ordinance passed, we would expect that property would be assessed under the replacement tax.
Okay, and one more question came in, and I want to make sure I'm understanding it correctly before I ask. But it gets to the point of, again, the notice having to be given, and then a board of supervisors contemplating the two options that we've discussed. And then it says there's no requirement under the new law for a utility to provide notice of intent. So the board is aware that they would need to make that decision. Is that a fair assessment?
Just going to read the question one more time.
Yeah, maybe I didn't do it justice there.
No, that's okay. I am not aware of a legal requirement for the utility to provide usage estimates. We think that the utility companies will play ball with you. Obviously, we can't guarantee that. I'm not sure I understand the second part of the question related to notice of intent.
Okay, so maybe that's getting to an earlier question about changing between the two options, and how long to be in place, or so I think my thought would be, going back to what we've discussed, you don't want to be in a position to be chasing. As county supervisors, you want to put yourself in a position to have that predictability, and kind of know what you're doing year over year. So with either option, I think you have that if you lock it in place. We talked about the stability of the replacement, or excuse me, of the special valuation, where you have a number locked in, your net acquisition cost, that it's going to be increasing 5%. But I think if you're trying to go between the two options, depending on what construction might be happening or other factors, I don't think that necessarily sets you up for the most success as far as good public policy to establish what you want to do, what your county's position is, and how property will be treated. We did get some follow-up, and this is a little bit of a tangent here, but related to a solar project coming in where they didn't get information ahead of construction. So construction had already begun. There was no requirement. I think maybe this goes back to what we discussed about, there are those concerns, but it's not necessarily related to the taxation. So I'm not sure if this is really the best forum to address that.
Totally understand why a board member would be concerned about that, but I can't answer that because it's really not a tax question.
Okay, I think we have gotten through the questions that have come in, and excuse me, I did try and bunch some of them together if they were somewhat related, but if you have follow-ups or would like to provide more clarification, if I seemed a little unsure of what you were asking, please do that. Anything else that either of you are thinking of or maybe wanted to make sure we addressed?
I don't think so. I know as these changes become effective and counties consider what they're going to do, we'll get more questions. So
Yes, and I guess to your point, Nick, these are conversations that need to be had at the local level. We certainly appreciate the guidance that revenue can provide, or some clarification on some things. But we do understand, first, you're not in a position to get in the minds of legislators, or maybe even the task force for that matter. And a lot of this is going to be specific to a number of things at the county level. So, what do you want your policy to be, as we've talked about, as you weigh what the revenue looks like? So, how are these properties assessed and taxed? What revenue stream are you looking at? And so that's, not only how these properties are treated, but then what effect does that have on the rest of the properties in your county? So it's kind of a larger, thought exercise on tax policy that counties might need to have for themselves.
yeah, I think that was really well said. I agree.
Okay, I'm not seeing any additional questions. So I guess the main goal here today was to address some of the questions that have come in, hopefully provide a little bit of explanation of not only the system that we're working within, but then what the task force was charged with doing, addressing an issue that maybe wasn't exactly clear in code, but again, we largely think that this legislation was clarifying so that assessors have clear direction, so boards of supervisors have clear direction so they can make the decisions for their jurisdiction. And we think that's accomplished with this legislation. Again, can't say enough. The task force coming together with stakeholders that were from different sides of an issue, and coming together and reaching consensus and coming up with a recommendation for the legislature, and of course the legislature and governor taking it from there and making the changes that were necessary. Certainly a good thing, but as we know, it did come with a lot of our members having questions. So hopefully today provided some information, some clarity. But of course, always feel free to reach out. The best email would be support@iowacounties.org. We can direct those questions to the proper place. And I think with that, I will just once again thank Roland and Nick for joining us today, the Department of Revenue for your continued support, guidance, and help, and being a great partner to counties. And thank you to everyone that was able to take some time today and join us. And this was recorded, and we'll make sure that the webinar is put on our website. So thank you very much. And with that, we'll sign off. Have a good afternoon.